Welcome back, everyone. And as y'all make your way into the salon and find your seats, we now welcome Chief Justice Carlos Muniz to the stage to moderate a panel on federal efforts to combat anti-Semitism. Chief Justice Muniz was appointed to Florida's Supreme Court in 2019. Prior to his appointment, he served as the U.S. Department of Education's General Counsel under former Education Secretary Betsy DeVos. Please give a warm welcome to Chief Justice Muniz, who will introduce the panelists.
Thank you very much, and I appreciate DFI and the Federalist Society for inviting all of us to be here with you today, and thank you for your interest as we talk about this compelling, fascinating, and difficult topic. Just to state the obvious, this is a very one of the things that makes it such an important topic, but also such a hard topic, is just starting with at the most basic level, is that there's a certain kind of moral imperative involved. I think anyone who saw what happened on a lot of our campuses after the October 7th terrorist attacks just has a natural kind of revulsion to it, and just a desire to do, whatever it takes to make sure that that sort of thing doesn't happen. And so that obviously creates a lot of policy challenges about what exactly to do and how to balance other values that we have and that sort of thing. Also, obviously, as someone, I have 3 kids in college, all of us who are parents know that the idea of any of our kids being subjected to what a lot of our Jewish students have been subjected to over the last couple of years is intolerable, and I think that also puts a lot of pressure on people to want to do something. On the other hand, it's also a tough issue because everything about it is contested. The definition of anti-Semitism is contested. Ideas about the extent of the problem. Obviously, we all saw sort of the most egregious abuses, but I think that there are differing views as to whether what's needed is just something kind of more targeted to address what we saw after October 7th, or whether there's a more kind of systemic and kind of profound dysfunction in our universities that requires a more comprehensive response. The whole notion of academic freedom, I think, is increasingly contested, and the extent to which that concept is intertwined with ideas about diversity of thought and that sort of thing. I thought it was pretty bracing for me at the lunch address when we heard Paul Clement as part of his remarks. Obviously the thrust of his remarks in general was very much trying to support the concept of academic freedom and everything, but at one point he said that the idea of an academic freedom that's divorced from true intellectual diversity and freedom of thought isn't worth fighting for. And so I think that some of what we're seeing is disputes about really, what is the state of the universities, and to the extent that that is what academic freedom has gotten us, to what extent is that worth fighting for? Does that need to be kind of reconceptualized? And then the final thing that I think makes it such a hard topic is that in addition to the fact that there are wide disagreements about ends, I think even among people who do feel compelled to want to do something about this, I think there are very hard decisions that folks have to make about what means are legal and what means are wise to pursue those. And I think especially for conservatives, I think that there's a sense that perhaps some of the approaches that are taken are sort of applying tools and ways of thinking about addressing things on campus that conservatives have been uncomfortable with in other contexts, and to the extent that they're applied here in the service of ends that maybe are more appealing, I think people struggle with that. And so I think we have a perfect group, I think, to be able to explore all those things. And so in the description for our talk today, the question was posed: are the current administration's enforcement efforts targeting campus anti-Semitism a welcome restoration of civil rights in higher ed, or are they blunt instruments that threaten academic freedom and independence from federal control? And so one of the things that I hope that we all emerge from, in addition to having some critiques of what's going on and maybe some alternatives and maybe some praise for what's going on, is just to really have a good sense of what is going on, because there's lots of moving parts. There's many different aspects to it. I think some of them are maybe more controversial than others. And so we have a great panel to explore that, starting with Ken Marcus, who I'll introduce here in a second. And I'm going to just introduce everybody all at once, and then we'll get the presentation started. And I kind of relied on the organizations that each of our panelists is affiliated with to kind of describe themselves and their mission. So if, when I describe what they do, I'm putting it in the terms of how they think of themselves and how they describe themselves. So Ken Marcus is the founder, chairman, and CEO of the Louis D. Brandeis Center for Human Rights Under Law, the mission of which is to advance the civil and human rights of the Jewish people and promote justice for all. In 2 different administrations, Ken has served as the head of the Education Department's Office for Civil Rights. He's widely credited with pioneering the use of Title VI as a tool for addressing anti-Semitism, and both inside and out of government. I think it's fair to say that Ken has been kind of both an action leader and a thought leader in addressing the problem of anti-Semitism in general, but especially on campuses. Ilya Soman is a professor of law at the Antonin Scalia Law School at George Mason University. I took Paul Clement's words to heart and made sure that I didn't just say professor at George Mason. He's also the B. Ken Simon Chair in Constitutional Studies at the Cato Institute. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. And he's written and spoken extensively on anti-Semitism and its underpinnings intellectually, philosophically, across the political spectrum. Sarah Parshall-Perry is the Vice President and Legal Fellow at Defending Education, which describes itself as a national grassroots organization working to restore schools at all levels from activists imposing harmful agendas and seeking the reestablishment of a quality, non-political education for all students. Like Ken and I, Sarah is also a veteran of the Department of Education. She served as senior counsel in the Office for Civil Rights. Before joining Defending Education, Sarah worked as a legal fellow at the Heritage Foundation. And finally, Tyler Coward. I figured we'd save Tyler for the last of our presentations, start with Ken, and then bring the heat at the end. Tyler is with FIRE. He's the lead counsel in government affairs at the Foundation for Individual Rights and Expression. Their mission is to defend and sustain the individual right of all Americans to free speech and free thought, and it considers itself the leading defender of fundamental rights on college campuses. Since joining FIRE, Tyler has testified about free speech issues in state legislatures throughout the country and has spoken at nearly 50 colleges and universities. So we'll start with Ken, who's going to give us his own views, but also kind of lay the foundation for the discussion, given his extensive involvement in these issues and also his familiarity with the Office for Civil Rights at Education. There's no one better able to kind of give us the lay of the land and give us a solid understanding of what the administration has been up to.
Thank you, Chief Justice, for those kind words. I'm humbled to be on this great panel and in this room with so many friends and distinguished leaders in this field. Congratulations to DFI and Federalist Society for the event. It is a fraught moment as we remember Charlie Kirk as Americans to realize the dark times that we are in right now. I remember him as a great American. He is also someone who was a great friend of the Jewish community, opponent of anti-Semitism, friend of the State of Israel. It is my view that for those of us who have been saying that there is a dangerous situation on college campuses for which Jews are, in a sense, the canary in the coal mine, when we talk about the horrifying changes on college campuses, we should think not just about what's happening to Jewish students on campus, but also how it spreads, how it affects non-Jewish Americans, and how it's also spreading to K-12, to the workplace, and to other sectors. It's now Constitution Day, I believe. It was on Constitution Day 21 years ago in 2004 that the modern period of federal enforcement on civil rights began. That was the day on which the U.S. Department of Education's Office for Civil Rights, for which I had perhaps in an improvident moment been appointed head, issued the first guidance indicating that under Title VI of the Civil Rights Act of 1964, the U.S. federal government would extend equal civil rights protection to groups like Jews, Sikhs, and others that have an ethno-religious component. That is to say, Title VI prohibits discrimination on the basis of race, color, or national origin, and federally assisted programs or activities like most colleges or universities. Jews had not previously received protection from the U.S. Department of Education from the time roughly in 1980 when the Carter administration carved ed out of HHS until 2004 based on questions about whether Jews should be protected. Those questions were essentially laid to rest 2004. So this is a 21-year period. The argument for protecting Jews under that statute is in part that it's compelled by the case of Shari Tefila versus Cobb, but also in part that ethno-religious groups are not just religious, but also share sufficient indicia of either race or national origin that they should not be divested of equal protection simply by the fact that they share a common faith. So we now have had roughly 21 years of federal enforcement, but it's not been an even 21 years. Between 2004 and 2010, generally speaking, OCR did not take cases involving anti-Semitism, and there's dispute as to whether leadership agreed with the policy then in effect. It has been since 2010, now 15 years, that administrations of both parties have agreed that Jews are protected, and yet, for several years, there were no successful complaints of campus anti-Semitism. There were a few complaints during the period 2010 to 2017, and that's not because Jewish students did not feel that they were facing anti-Semitism. While the reports of anti-Semitism were far lower between 2010 and 2017 than they are now, there were any number of different reports, government reports, academic reports, surveys, anecdotal information to suggest during that period there was a growing amount of anti-Semitism on college campuses, and yet the federal government, and in particular the U.S. Department of Education's Office for Civil Rights, or OCR, was not acting against it on any college campus. What happened in 2017 was the election of Donald Trump. With the Trump administration, and I served again as head of OCR, there was a newfound concern that this tool, Title VI, should be applied in a way that is even-handed with respect to Jews and non-Jewish students, and that where there is an appropriate complaint, it should be treated in the same way as any other case. That administration led, among other things, to resolution agreements involving anti-Semitism allegations at my alma mater, Williams College, the University of Carolina, Duke University, and NYU. It was a small group, but these were really the first successful resolutions, and it was during the Trump administration. Sorry, I'm speaking fast because I'm trying to give you some background so that you know this is not coming out of nowhere. During the Biden administration, there was really nothing happening for the first couple of years, despite the fact that there was a continued surge in reports of anti-Semitism, even before October 7, 2023. The year leading up to October 7, 2023, I would say we received as many concerns expressed to us in intake as perhaps the whole prior history of the Brandeis Center. It was a bad time, and yet the cases were trickling into the Biden administration. After October 7, 2023, there was a newfound understanding that we were seeing something that could be characterized as a crisis, and that was seen, I would say, across the board among both Democrats and Republicans. The Biden administration became the first Democratic administration to use Title VI in the same way that it was being used for other groups other than Jewish Americans, which is to say it investigated a significant number of allegations, dozens out of maybe tens of thousands of total complaints. There were dozens involving anti-Semitism. They investigated these and issued a handful, dozens of resolutions, a large part of which came after the re-election of President Trump. That is to say, after the re-election of President Trump, you had two different things happening. On the one hand, you had a Biden administration recognizing that Jews should get the same protection as other groups. And on the other hand, you had an incoming president who was viewed as speaking very strongly about anti-Semitism and concerned that if they didn't enter into a resolution agreement, there could be worse things happening. We saw dozens of these agreements. It is my observation that there were significant changes at many universities as a result of these, and yet the Biden administration was criticized by many of us, and certainly across the board within the Republican circles and within the Jewish community, for being relatively weak, not relative to the history of OCR, but certainly relative to the demands of the moment. And the question has been, what about this apparatus under Title VI that is only finally now being used during the first Trump and Biden administration, and yet it is time-consuming, it is clunky, it requires enormous amounts of resources, and while the one remedy truly available to the federal government is termination of federal funds, that was never happened, never almost happened in all of those years. And so the question as we reached the beginning of the Trump administration was, when we have this extraordinary situation, this apparent crisis on campuses all over the country, are we going to use the same apparatus that had hardly ever been used, but which seemed to be slow-moving, cumbersome, and of questionable effectiveness? Or do we do something stronger? Is there going to be some way to truly get the attention of higher education so that they will understand that there is a fundamental challenge manifesting itself as anti-Semitism, but arguably deeper even than that? And how do you do it? So now we've had the Trump administration, and I suspect that we might all agree that the approach of the Trump administration has been utterly unprecedented. It's been utterly unprecedented in this term in the number of cases handled, in the forcefulness, and in the extent to which the entire federal government, or at least numerous parts of it, have been involved. Certainly that includes the U.S. Department of Education's Office for Civil Rights. It also includes the Department of Justice, which had been relatively insignificant in dealing with anti-Semitism cases, even during the crisis that preceded it. But it's also included other agencies like Health and Human Services, which suddenly has awakened to its potential role in civil rights enforcement, and critically, and this was, admit it, not on your bingo card, the General Services Administration. When this administration figured out something about civil rights that prior administrations hadn't, which is that when it comes to universities that are recalcitrant about civil rights, we have not only Title VI, but we have other tools. Title VII, of course, employment law and the Equal Employment Opportunity Commission, which also woke up this year under interim chair Andrea Lucas. But now there was also this notion that while we can use the Title VI apparatus, and it is being used apparently in dozens of cases now around the country quietly, there are also other approaches. What we have seen from this administration is that when there are massive contracts going to colleges and universities, the administration is taking the position that it can use the discretion provided under federal procurement law and under the terms of specific contracts to the same extent as it could in any other case. Generally speaking, federal acquisition rules, which admittedly I'm not an expert, but federal acquisition rules provide lots of discretion for the government to terminate even on grounds of convenience, and certainly usually for grounds of Title VI. So I'm going to try to wrap this piece up when I say what we've seen now, at least in a few key cases, has been a muscular enforcement that has involved cessation of contracts, not just under the usual Title VI rules, but rather under contract rules that had previously not been used under civil rights, but which clearly do have provisions that give great discretion to the federal government on how to use it. Now, what I'll say in just wrapping up, because I was mostly trying to give a little bit of background, is what you are seeing in the Trump administration, it is forceful, it is somewhat broad. We heard this morning quoted that a federal judge in Boston has argued that what the Trump administration is doing on anti-Semitism is a smokescreen for addressing other issues. And that's in part because resolution agreements in these cases often deal with other things like DEI or transgender issues or the like. It seems to me that all you have to do is spend a little bit of time with anyone in the administration working on this issue to know it's not a smokescreen. You can also look at the way in which the administration has treated other things, like its negotiation with the law firms to make sure that they're addressing anti-Semitism even when it doesn't arise, or looking at huge grants like TICFA to see that this administration, whether you agree or disagree, whether you agree on the law or you don't, it is taking anti-Semitism with a seriousness that hadn't been used previously, that it is meeting the moment in a way that has a forcefulness, a muscularity, and I would say a creativity that is greater than what we have seen before, and that this sort of power, this sort of strength, this sort of innovation and creativity is absolutely what has been needed in the civil rights crisis that we have faced on college and university campuses.
Thank you, Ken.
Thank you.
Professor?
Sure. So thank you to DFI and the Federalist Society for organizing this event and all of you for coming. My talk is going to cover two sets of issues. One is sort of what is or is not campus anti-Semitism and where it is or is not appropriate to use a tool like Title VI, and then the problem of federal overreach using the issue of anti-Semitism and sometimes, frankly, just a pretext of anti-Semitism to try to impose extensive federal control over university governance, which turns into a serious threat to free speech, academic freedom, and also federalism. So first things first, I think it's undeniable that a good deal of what Ken just said is true. There were serious incidents on many university campuses with harassment, intimidation, exclusion of students, in some cases Jewish students, and others just students perceived rightly or wrongly as being pro-Israel, and so forth. And a lot of that conduct was illegal, though as I'm about to say, in some cases it was illegal under laws other than Title VI. Nonetheless, there is a complicated legal issue, sometimes complicated, about whether this is actually covered by Title VI or not. In some cases, I think it clearly is. In some cases, maybe not. As Ken noted, Title VI focuses on ethnic discrimination, racial discrimination, discrimination on the basis of national origin. There is a history of argument over how Jews fit into that. I actually totally agree with Ken and others that Jews do fit into an ethnic discrimination pattern. Whatever is the true nature of Jews, whether we're truly an ethnic group or a religious group or some combination of both, for purpose of Title VI law, I think we do qualify as an ethnic or national origin group, and therefore anti-Semitic discrimination is similar to, say, discrimination against black people or Hispanics or some other ethnic or racial group. And I think that issue is relatively clear. However, when harmful action happens, if it's to be considered anti-Semitic discrimination, it has to be actually targeted at Jews as opposed to some other characteristic. And here we face the question of whether anti-Zionism, for example, necessarily qualifies as anti-Semitism. Sometimes I think it clearly does, but there certainly are people who have objections to Zionism which are not based on anti-Semitism. I, to some extent, am one of them myself. I object to ethnic nationalism of all kinds. Even wrote a book where I discuss why I have that view, and therefore I could be wrong about that, but I don't think that view is inherently anti-Semitic any more than it's inherently anti-French nationalism or German nationalism or Russian nationalism or some other kind. While in the real world there is definitely overlap between anti-Zionism and anti-Semitism, it is not always the same thing, and incidents motivated by anti-Zionism, while still reprehensible in other ways, may not qualify under Title VI. Similarly, there may be other ideological motivations for what some of these campus activists did. Some would involve left-wing ideology, Arab nationalism, or other kinds of views. That doesn't justify what we did or what they did. And I totally understand that from the standpoint of the victims, it may not matter that much were you intimidated or excluded because you're Jewish or because somebody had a left-wing ideology or had some other objective. From the experience of the victim, it may not matter that much, but from the standpoint of what is the appropriate legal remedy, it does matter, because a remedy aimed at ethnic or racial discrimination is not properly applied to these other kinds of things. Moreover, there is a question of, well, what about a lot of these remedies are aimed at the schools rather than the students or activists who did the initially legal actions. If the school's motive was anti-Semitic, then they're clearly motivated by that and covered by Title VI, but if their motive was something else, then that may not be the case. And here it is often said, well, imagine white nationalists did similar things, would the schools have acted differently? I think in many cases the answer is obviously yes, that they would have acted differently if white nationalists had done something of the kind that left-wing and other activists did over the last couple of years. But that answer has a flip side, which is that if they indeed would have acted differently had white nationalists did that, then that suggests the school's motive was not anti-Semitism, but rather some kind of bias in favor of misbehavior by left-wing protesters as opposed to right-wing ones. And that, legally speaking, is a significant distinction. Even if the school's motive was not anti-Semitic, the current precedent says they might still be liable under Title VI or related laws if they displayed, quote, deliberate indifference to the anti-Semitic or discriminatory actions of students or even perhaps of outsiders who get onto the campus. In some cases, I think maybe it does meet that deliberate indifference standard, but in some cases of merely like not acting as fast as would be desirable, it might fall short of it. So we have to be careful about applying Title VI to situations where it might not be applicable. I would add that just because a Title VI remedy or a federal law remedy is not available, that doesn't mean that nothing can be done. There are obviously state criminal law remedies, and indeed, in some cases, people have been prosecuted, like in the Columbia cases, for example. There are obviously also civil law remedy. The students might have various remedies they can pursue in court. I can talk more about those in questions. But federal intervention and federal anti-discrimination law is not the solution to all problems in this area. It's important to recognize the predominant role of states and localities in these. Conservatives traditionally understood that. They should understand that in a case like this as well. Now to the issue of federal government overreach. What has happened under this administration is indeed in various ways unprecedented, and some of it really goes into areas which have little or nothing to do with combating anti-Semitism and is instead an attempt to assert federal power over higher education in various harmful, illegal, and dangerous ways. An obvious example is speech-based deportations of foreign students, and in some cases employees or faculty members, often even for speech that is not endorsing terrorism or is not anti-Semitic unless you define anti-Semitism super broadly. This violates the First Amendment, and it certainly has little or nothing to do with actually combating anti-Semitism. Elsewhere, and I have argued that it is not true that there's somehow an exception for non-citizens to the First Amendment, and indeed the Supreme Court has said since 1945 that non-citizens do in fact have First Amendment rights. In addition, there is the problem, even where Title VI may be appropriate, this administration has often failed to go through the proper Title VI processes. They may be cumbersome, and there's problems with them. I'm not saying those processes are ideal, but on the other hand, they do prevent the use of Title VI as leverage to try to take over university governance. And as the recent ruling in the Harvard case showed, and this is also true in Columbia and some other examples, the administration has simply ignored those appropriate processes in many cases. They have also sought to control aspects of university governance that go far beyond any reasonable agenda of combating anti-Semitism or any other kind of discrimination, seeking to control faculty hiring, curriculum, or even seeking removal of university presidents that they don't like. I don't especially like some of these university presidents myself, but in my view, the selection of the president of a state university like the University of Virginia, that is a function for the state of Virginia, not for the federal government. It's important to maintain diversity and competition in our education system and not have one single unitary form of federal domination. Similarly, we have in the Harvard case and elsewhere funding cutoffs that are motivated by political speech and the like, and cutoffs in areas that again have little or no connection to anti-Semitism or any other kind of discrimination, including cutoffs in areas of scientific funding and the like. This is a problem from the standpoint of the First Amendment. It's also a problem from the standpoint of separation of powers, because it is Congress, not the president, that is supposed to have the power of the purse. So more can be said, and of course we probably will say more in the course of this discussion. For now, I say there are some genuine problems, not just with anti-Semitism, but even more generally with allowing sort of excessive protest or violence and disruption on some college campuses. But the solution to that must not open the door to federal domination of higher education in this country. That is the kind of thing that undermines the virtues of our federal system, and it is also the kind of thing that is characteristic of authoritarian regimes where you have a central government seeking to control education and imposing its own uniform ideological vision on it. Thank you.
Thank you very much. Sarah?
Well, my, my remarks today are different than I set out to write them a week ago because I think the aperture between speech and violence has narrowed significantly in light of what happened at Utah Valley University last Wednesday. And I do believe, as Ken mentioned, that anti-Semitism has been the canary in the coal mine that has actually allowed incidents like we saw in the state of Utah to transpire. So I'm going to lead with a few statistical analyses, only because I think it's important to really state accurately the magnitude of the problem. I hope not to bore you. I'm also fully cognizant of the fact I stand between you and cocktail hour, so I will make this very entertaining. What has become clear, and I think we all recognize this, is that the actions of higher education institutions, their defense of Hamas's violence, their platforming of Students for Justice in Palestine, their pedagogical matrix of oppressor and oppressed victim mentality, and their essentially platforming tyranny on college campuses has really led to the common current moment that we experience right now. A full 34% of American college students believe violence is acceptable to stop speech with which they disagree. 34%. That should terrify everybody in this room. 7 in 10 students believe that speech can be as damaging as physical violence, which may indeed actually in turn platform an opportunity or an excuse to a moral imperative for responding with violence. 80% of students coming out of the University of Northwestern in Chicago actually were surveyed, and it was determined that 80% of them self-censor or represent more liberal perspectives on a false front than they actually hold, being more conservative internally, but that they are afraid that they will lose social or academic standing if they do not present themselves as being more liberal. 71% believe it's acceptable to shout down a speaker. 54% believe it is acceptable to bar ingress and egress for a speaker they do not like. That, of course, gave rise to the situation we saw with Judge Duncan. There's been a 360% surge in anti-Semitism on college campuses since October 7th. And Columbia University, who really was public enemy #1 for many respects, I think, revealed in a 2025, so very recent report, that 53% of Jewish students reported to being subject to discrimination on college campuses because they were Jewish. 59% believed they would be better off by conforming their beliefs to campus orthodoxy. 62% reported a low sense of acceptance based on their religious identity. And as Jewish students and teachers recognize, anti-Semitism in the academy is not rare, it is routine, and that is a huge problem. A college's purpose isn't just to merely encourage speech. Obviously, it is one of the highest aims of higher education, but it is also to educate. And speech and education must transpire together in an area that is free of combat war zones, of encampments, of vandalism, of physical violence. These are natural exceptions to First Amendment conduct that should be easy for all of us to get behind. And in fact, in many respects, maybe that is perhaps a jumping off point, that we plumb the depths of those specific categories, accepted categories to free speech, whether that's lawless incitement to violence, whether it is true fighting words, whether it's conduct, it's speech in furtherance of a criminal enterprise, whatever those are, perhaps that's something that we can discuss on this panel today. I want to talk a little bit about Title VII, but before I do, I want to discuss the interrelationship between civil rights law and First Amendment jurisprudence, because the Supreme Court's actually given us a lot of good clarity on this front. The two are not, and I'm cheating a little bit because I think it's something that we're going to discuss on this panel anyway, but I don't consider the two to be mutually exclusive. Even when the Constitution prohibits coercive governmental interference with specific individual rights, like First Amendment rights, it does not confer an entitlement to such funds as might be necessary to realize all the advantages of that freedom. That's 1988 from Lynn versus United Area Auto Workers. That is why refusal to fund protected activity without more cannot be equated with the imposition of a penalty on that activity. That was the Supreme Court's dictum in 2003's United States versus American Library Association. Time and again, we've seen that, yes, you may engage in conduct that could be considered anti-Semitic, but you don't have to be funded for it. And in fact, I believe the Trump administration has taken some of these edicts to heart. A funding condition can, of course, result in an unconstitutional burden on free speech, and the line is hardly clear, as we were just told in an executive order, in a judicial ruling upholding the constitutionality of DEI executive orders on a First Amendment challenge. But specifically, we want to take a look at whether or not the activity that the government wants to subsidize seeks to leverage funding, and I believe the professor would agree that this is precisely what's happening now, leverage funding to regulate speech outside the contours of a specific program or activity. There exists no First Amendment right to violate civil rights law, and to the contrary, the Supreme Court's clearly held that the First Amendment does not protect the very act of discriminating on the basis of race. More generally, the right to speak freely provides no shield for private individuals or institutions that engage in discrimination that violates federal law. Now, let's look specifically at Title VII, which I believe has been the most effective employment of these particular anti-Semitism prohibitions throughout all of the federal government. It's worked well because, among other things, it includes protections based on religious belief. That is, I believe, something that Title VI, further down the road, could benefit from further amendment. I think it would allow Jewish students on college campuses, for basis of their Jewish belief, their Jewish faith, to realize identical protections that we've seen in the academy with professors, staff, and administrators. Recently, as part of the Trump administration's $221 million settlement with Columbia, the very quiet part, the ancillary to that, was a $21 million settlement with the Equal Employment Opportunity Commission for anti-Semitism against Jewish professors on staff. Now, a 2024 report from the American Jewish Committee says that 16% of American Jews, just 1 year ago, have avoided wearing or displaying something in the workplace that would identify them as being Jewish, simply because they are afraid of being discriminated against. 9% have felt uncomfortable or unable in the workplace because of their Jewish identity to talk about who they are and what they believe. So Title VII of the Civil Rights Act of 1964, again, does something that Title VI does not, which is including religious protections as well. There's an opportunity for multi-level recovery here, whether on race, national origin, or on religion. And of course, however you identify the American Jewish individual, multiple categories of protections can inure and do inure for purposes of Title VII. It obviously prevents disparate treatment, direct treatment. Unfortunately, it also protects against disparate impact. That's until we see the Supreme Court overrule Griggs versus Duke Power, which I've argued for a long time, or we see the rescission of the 1991 amendment to the Civil Rights Act, which cements the holding in Griggs versus Duke Power. There is rulemaking underway, parenthetically, to actually eliminate disparate impact enforcement. It also prevents, obviously, against harassment, and that is a portion of what we're seeing this administration take very seriously to heart. It does not take lightly the drawing of swastikas on chalkboards. It does not take lightly anti-Semitic tropes, within the employment context at least, and here is where we really do have clarity from the administration and where the lines really are clear on what's protected behavior and what is not. It also, obviously, includes failure to accommodate religious practices, and here is, again, where it's been the most beneficial for protection of professors in higher education based on their religious identity. In fact, we've actually seen some increasing clarification from not only the Supreme Court, but from the Equal Employment Opportunity Commission. And by the way, there are related regulations through the Department of Labor which prohibit liberal contractors, federal contractors, rather, from discrimination in employment based on race, color, religion, sex, the same categories, obviously, that we see protected in Title VII as well. But there are two regulations. One of the two regulations, which is actually 41 CFR 60-50.2, if you want to look it up, actually provides in that religious guidance that the Jewish identity and its connection to Israel is endemic to who the American Jewish individual is. And that, I think that'll be something that we can discuss further, that relationship between Jewish identity, Zionism, stances on Israel, the war in Gaza. Naturally, that further complicates the discussion about protection of Jewish staff and faculty on college campuses. What does this look like in practice? Columbia University, actually, after it settled with the federal government, appointed Jonathan Kahn to be Senior Associate Dean of Community and Culture even though he had signed a 2021 statement backing the indigenous resistance to the war in Gaza against Israel, and it yielded significant blowback from Jewish students and faculties about that professor's suitability to lead open dialogue on campus. So then we have to ask ourselves, is it necessary to disrupt the ideological ecosystem that treats Jewish students as outsiders, Zionism as genocidal, and Israel as an illegitimate state? These are questions for which I don't have facile answers, but I'm hoping that we can discuss some of them here today. The Trump administration has, blessedly, and this was a move I think was exceptionally wise, backed off major changes it had initially floated that were very aggressive within the employment stance, such as forcing out certain pro-Palestinian faculty members or placing Middle Eastern studies departments into academic receiverships in which it would lose ultimately control over many, if not all, of its affairs. That was a wise retreat, I believe. What we see now in terms of enforcement. In 2021, and we're talking now modern parlance from the Trump sort of 1.0 era to the current day, 2021, the Equal Employment Opportunity first came out and offered extraordinary protections of passing a resolution, something that was historically never done in the past, condemning the rise in anti-Semitism across the country, including the workplace, and clarifying exactly what would look like anti-Semitic violations. In 2023, the government unveiled its national strategy to counter anti-Semitism, a comprehensive response to the alarming growth in anti-Semitism in other places, including the workplace. In the same year, the Supreme Court in Groff versus DeJoy, and this was sort of the sleeper hit, I think, of that term, overruled Trans World Airlines versus Hardison, the 1977 case that said employers could decline any religious accommodation request for anything more than a de minimis impact on that employer's operations. Well, now, with the overturning of TWA, this is an opportunity for Jewish employees in all public sectors, in any employment setting with 15 or more employees, not just in academia, but now throughout any area in corporate America, to say, this is a religious accommodation I need. You have to show me that it would be a substantial impact on your operations to actually decline. We also saw a great decision in Ames versus Ohio Department of Youth Services. This is another sleeper hit. I was just talking to Shauna Bray, its CEO, today about this. It's a case we love. There is no higher burden of proof for one individual plaintiff over another within the context of Title VII law, specifically because, shock and awe, that would defeat the actual purpose of civil rights law in the first place. And then, of course, we saw agency guidance to all the federal executive agencies from Pam Bondi's office on July 25th, 2025, explicitly laying out where the protections existed in Title VI and in Title VII, among others, and laying out specific incidents of what might constitute anti-Semitism. So I think they are trying very, very hard to be very specific, but we understand that these are very murky constitutional waters. In the end, my number one solution, in addition to what the Honorable Paul Clement suggested at the lunch break, in addition to ideological viewpoint and diversity, would be to amend Title VI to include religion.
Thank you, Sarah. Tyler?
Thank you. Thanks for the panelists, and thanks for DFI and FedSoc for hosting this. I'm feeling a little unwell, so I appreciate your patience here. But let me begin where I think we all agree. Universities have a moral and legal obligation to respond to known instances of unlawful discrimination occurring on their campuses. We also agree that Jewish students must be equal participants in campus life and have access to their campuses free from unlawful discrimination. The question today is not whether to enforce federal civil rights laws, it's how. And on the how, the Trump administration's current approach is unlawful in process and unconstitutional in application. First, the process. The Trump administration formed a multi-agency anti-Semitism task force and launched coordinated campus investigations against higher education institutions that may have violated Title VI by allowing unlawful campus anti-Semitism to go unaddressed. The creation of the task force is in itself unlawful, but it is unlawful to revoke grants and contracts to universities for maintaining alleged hostile environments on their campuses based on race, color, or national origin outside of existing Title VI procedures. Federal law and regulation says that the Department of Education cannot suspend, terminate, or refuse to grant financial assistance unless the department has advised the recipient of its failure to comply with Title VI and has also determined that compliance cannot be secured by voluntary means. That's a requirement. 2, that there has been an express finding on the record after opportunity for a hearing of a failure by the applicant or recipient to comply with a requirement of civil rights law. And 3, the Secretary of Education has provided Congress a report of the circumstances surrounding the funding revocation, and 30 days have passed since that report was filed. To our knowledge, the Trump administration accomplished none of these steps. And it did not do so before withholding billions of dollars from Columbia, Harvard, and other universities. If you want a case study in an unlawful process, take a look at the government's March letter to Columbia University. It laid out 9 preconditions for even negotiating restoration of federal funding, a far cry from Title VI's demands that the government seek voluntary compliance before defunding an institution. The administration's demands included abolishing the University Judicial Board and centralizing discipline in the president's office, imposing a mask ban, placing an academic department into academic receivership, and demanding that Columbia, quote, formalize, adopt, and promulgate a definition of anti-Semitism, strongly suggesting that Columbia adopt the legally dubious International Holocaust Remembrance Alliance definition of anti-Semitism. And courts are already seeing through it. As we've mentioned already, earlier this month, a federal court in Massachusetts granted summary judgment against the Trump administration in key aspect of Harvard's litigation against it. The court set aside the administration's funding freeze and termination of grants as violations of the First Amendment and Title VI. To paraphrase the opinion, the government cannot impose viewpoint-based conditions, including a demand that the institution hire faculty to promote viewpoint diversity on a university's research funding, and it cannot bypass statutory procedures Congress wrote into Title VI. That should matter to everyone in this room who cares about the durable enforcement of our civil rights laws. If the government cuts corners, it should lose. And when the government loses on process and constitutional grounds, it not only loses credibility, it also fails to meaningfully protect Jewish students who have suffered actual unlawful discrimination on their campuses by incurring unnecessary delays. The government should strive to get it right the first time. And legal conservatives should recognize this pattern. Many of us spent the 2010s fighting the Obama-era Title IX Dear Colleague letter regime. Urgent mandates imposed without notice and comment rulemaking, so-called guidance that threatened actual punishment for noncompliance, and campus disciplinary investigations that stacked the deck against accused students in order to protect favored communities on campus. And the litigation record against this regime was unmistakable. Fire friend Casey Johnson and former fire staffer Samantha Harris document the wave of lawsuits filed by accused students who suffered under this regime. Over 200 courts found, at least in some stage of the litigation process, in favor of accused students alleging due process violations that occurred under that regime. The bottom line is that when federal agencies abandon process and push colleges to adopt constitutionally dubious systems, the lawsuits start to pile up and courts will push back. If we care about the rule of law, we should not repeat the Obama administration's mistakes under a different banner today. And now to the outcomes. Even setting aside the process shortcomings, the demands levied by the Trump administration are constitutionally fraught and practically counterproductive. Let's start with the compelled definition of specific definitions of anti-Semitism. The government cannot force institutions, on pain of losing federal dollars, to enshrine a definition of anti-Semitism that sweeps in core, protected, political speech critical of Israel. Whether you agree or disagree with the definition and examples incorporated in the IRA definition, using them as an enforcement cudgel invites our universities to punish protected political speech on behalf of the federal government. Next, restructuring university governance by federal fiat, placing entire academic departments into academic receivership, demanding viewpoint diversity in faculty hiring, bear little to no relation to federal civil rights enforcement and threaten to turn private universities into federally controlled fiefdoms. We can insist on vigorous Title VI enforcement without abandoning the rule of law. Title VI protects Jewish students from discrimination based on actual or perceived shared ancestry or national origin. When harassment is targeted at an individual and is so severe, pervasive, and objectively offensive so as to deny that students equal access to their education, schools have an obligation to act. The fix for under-enforcement of Title VI is not to invent new powers or impose political conditions on institutions wholly unrelated to combating unlawful anti-Semitism. It's to use the process mandated by Congress and federal regulations, and to use the definition of discriminatory harassment mandated by the Supreme Court of the United States. Anything else is legally suspect. In addressing unlawful anti-Semitic conduct on campus demands a serious response. Our Constitution and our civil rights laws give us the tools to do so. So let's use those rules carefully, transparently, and with respect for the First Amendment and institutional autonomy. That's how we protect Jewish students from unlawful anti-Semitic harassment, preserve free speech, and academic freedom. Thank you.
Thank you, Tyler. I appreciate it. Ken, do you want to, before we get to questions, do you have any thoughts and a response?
Sure. So first, I'm delighted there's so much area of agreement. Let's speak no further of that. On the other issues, I'll touch on just a few. First, we've heard now from more than one speaker that we have no commonly agreed upon definition of anti-Semitism. And since there seems to be some disagreement here about the definition of anti-Semitism, that seems to be evidence of it. But I consider that to be false. If anything has an agreed upon definition, it's anti-Semitism. Think by comparison of sexual harassment, where we have a different definition with every presidential election, and where state attorney generals think that it's worth fighting about in court, as we see over and over again. By comparison, the definition of anti-Semitism contained within, I won't go into depth, but it's called the IRA working definition of anti-Semitism. It was alluded to a moment ago. It has been adopted now by a supermajority of U.S. states, starting with red states, but it's more than 2/3 now. Also by the Trump administration, but before that, Biden, Obama, and George W. Bush administration, and over 30 other countries around the United States. There are a few other legal terms that have that much agreement. So while it's true you can disagree about anything, especially when you have either lawyers or academics or both, this does have a certain amount of widespread agreement. As used within the Trump executive order on combating anti-Semitism, IRA is used not to suppress speech, but rather to determine the intent of conduct, which might be anti-Semitic, if that's pertinent to, for instance, the nature of the remedy that's available. Second, deliberate indifference was discussed a moment ago. The one thing I'm going to say about it is we heard from Paul Clement earlier that at UCLA, he found clear conduct. What I see is over and over again people being surprised that they think from the media that when we talk about campus anti-Semitism, we're talking primarily about speech. And yet over and over again, we're seeing cases involving physical violence, various forms of obstruction, vandalism, so on and so forth, which is why, although the First Amendment is litigated sometimes in these cases, it's usually not that. It's usually about whether the standards of deliberate indifference are met. Third, on Title VI processes, well, this is a complicated one, but I'll say this. I think we have a situation here where there is a very clear, specific Title VI process from Congress and regulation, and a different set of processes under our federal acquisition regulation. One side will argue, as Harvard has, that once Congress created a cumbersome Title VI process, the federal government can no longer apply the acquisition rules in the usual way. Well, that suggests this weird situation where the federal government can cut a contract unless there's some sort of racial or ethnic discrimination, in which case it has to use something different. There are some times where Title VI regulations clearly are necessary, where one is not just cutting a contract, but actually preventing an institution from receiving any federal funds whatsoever, now or in the future, but that's different. The last thing I'm going to say, actually, this, Sarah, you suggested that Congress should amend Title VI to prohibit religious discrimination or harassment. A little shocking that it hasn't done that yet.
Yeah.
I think even FIRE has supported that in the past. Let's get going.
Yeah, we agree with that too. It's one of our solutions, alternatives to adopting IRA. Ken and FIRE, we've had long-standing disagreements about the incorporation of IRA, but certainly adopting religion as a protected class for Title VI purposes is where we do share some common ground. Pair that with codifying the guidance that Ken wrote, maybe I'm true, but in 2004, saying that Jewish students and Sikhs and others can avail themselves of Title VI for ethno-religious, because of their ethno-religious and ties to Title VI national origin and ethnicity, codifying that as well as religion, and codifying once and for all the Davis standard
Yes.
that is required by the Supreme Court. That's our three-step solution that we've come up with that respects, vigorous Title VI enforcement while ensuring that First Amendment rights aren't violated in the process.
Yeah, can I just add to that? It's so funny that you said that because Davis is on my list of proposed solutions as well. If we could finally get that cemented once and for all so that it is severe, pervasive, and objectively offensive, then we won't play sort of hide the ball with what is and is not sufficient harassment for purposes to rise to the level of a Title VI violation as well. I also wanted to mention something about IRA. Columbia declined nicely to adopt the definition of IRA upon request from the Trump administration. But what it did actually, I think, was a suitable substitute and was sort of a measure of goodwill, I think, for students and faculty and staff, because what it said was that it would enforce a policy recognizing that anti-Semitism can deny Jewish people the right to self-determination and will apply double standards to Israel. In other words, its recognition of what that is like in lived experience for Jewish students and faculty was its goal of being, quote, in the spirit of IRA. So I think there are opportunities there to enforce policies, if not directly related to the IHRA definition or to Title VI specifically, to at the very least engender goodwill with staff and students.
Let me ask my first question. Let me ask, and this kind of goes to Ken and Tyler, because I want to focus preliminarily on kind of the effect of students, both on the and in the context of free speech. So both in the context of the speaker whose speech may be restricted, and also the person who's we're focusing on the effect of the speech. And so I guess I'm curious about how each of you thinks that the deliberate indifference standard interacts with the definitions of speech, because obviously part of that gets to deliberate indifference to what, and to the extent that schools are going to use their disciplinary processes to show that they aren't allowing anti-Semitism on campus and that they are responding, it seems like in that situation it really does matter how you're defining sort of what it is that's going to trigger the need for the school to be responding in the first place. And so I think that is where maybe I think there may be some room for disagreement as far as what is it that students have to be subjected to before the school has to get involved, which then ultimately kind of shapes their potential liability under Title VI. So can you address that?
Yeah, so when there is a bias incident that rises to a certain level, federal recipients need to respond promptly and effectively. When it comes to universities, that can mean three things, each of which should be examined, I would say, virtually all the time. First is the question as to whether there has been a violation of conduct rules that might lead to discipline. That question is a fraught one that is restricted by various rules, including, especially in public institutions, due process, free speech, et cetera. Second is whether there is a need for some sort of supportive measure to support the targeted student or community. That is typically not restricted, but is often important. Third is whether, apart from the question of discipline, there has been a change in the environment on campus such that students of a particular group might feel that they lack equal educational opportunities, and there are different sorts of measures that may be taken to make sure that the affected group feels fully included or welcomed. That is also not subject to either due process or free speech requirements. So there are various ways in which an institution can respond in a way that is prompt, that is effective, and that is robust, but that does not restrict either speech or any other applicable rights.
Yeah, let me just let Tyler respond, and then you can, Tyler, go ahead.
Yeah, well, when I think through this, especially when it comes to a lot of the speech controversies that happen on campus, I think deliberately indifferent to what? To protected expression. Well, then what is the institution supposed to respond to? During the Biden administration, we had our qualms. We've talked here today about the Trump administration's handling of Title VI investigations. A lot of these investigations were open under the Biden administration, and some of the findings and reports were really legally dubious. For instance, what comes to mind is at Lafayette College, where there was a lot of pro-Palestinian or anti-Israeli activity on campus, but also a lot of social media campaigns or students voicing opposition to Israeli policy on social media. And among the factors that the Biden administration's Department of Education listed for dinging Lafayette College for failing to respond to allegations of anti-Semitism were Instagram messages that somebody posted on their story or something they posted online off campus. The administration there, or the college said, well, we can't police off-campus speech. This is protected expression. We can't touch this. And so the Biden administration found them deliberately indifferent to that off-campus speech, and so they sort of created this cumulative theory of harassment, that there was so much protected speech happening that some people on campus found offensive, that the college had a duty to respond to it. And I think that cumulative theory of harassment, that there was too much protected speech, is incredibly dangerous, incredibly chilling. If I were a university general counsel reading that report, the only thing I can take away from that is I need to censor more, or else OCR is coming after me and I can lose my access to federal dollars. And I think that's sort of anathema to how our civil rights law should be enforced.
Professor?
Yeah, so on the issue of deliberate indifference, I think it's worth making a couple points. One is deliberate indifference is something that applies in a situation where it's not the school directly that's discriminating, but rather students or contractors or even sometimes outsiders that come into university campuses and the like, and then the school, chooses not to act against them, but deliberate indifference is at least a somewhat high standard. It's not enough that the school acted too slowly or not as efficiently as it should have, but that there has to be an ongoing pattern of essentially doing little or nothing despite there being a severe problem. The Davis case referred to earlier was a case where one student had been sexually harassed by another for many months on end, and the school administration was well aware of it, but they did little or nothing to protect her. So I think there are some of these cases which probably do meet the standard of deliberate indifference, but quite a few others probably do not, and the current administration, to put it mildly, has not been careful to distinguish between the two situations. The second point to make about deliberate indifference is it's quite right to ask deliberate indifference to what? And here's where I think an overbroad definition of anti-Semitism can be a serious problem, and ironically, conservatives and libertarians have a history of pointing out serious problems like this with other overly broad definitions of other kinds of discrimination, with racism, sexism, and homophobia, and so on. And here, too, whatever might be the merits of the IHRA definition as a moral definition or a political definition, if you apply it to these legal contexts, then you get things like, as already been mentioned, I think that denial of the Jewish people's right of self-determination turns out to be anti-Semitism. Well, what if you just deny ethnic nationalism in general? What if you believe, as actually do believe, that no ethnic group is like the exclusive owner of a particular territory and no government has the right to engage in racial or ethnic discrimination? That denies some of the principles of Zionism, but by the same token, it denies French nationalism, German nationalism, and yes, Palestinian nationalism as well. I also don't believe that there is a justification for an exclusively ethnically Palestinian state or other ethnically Arab state and the like. You can argue, that's wrong, and it's certainly, maybe an unpopular view, but I don't think it fits the legal definition of anti-Semitism, which is bias against a particular racial or ethnic group. And there are a lot of other things that the IHRA definition also includes that I don't think fit well into a proper definition of legal, racial, or ethnic, or national origin discrimination, even though you can argue about whether in some moral or ethical or political sense this kind of thing qualifies as anti-Semitic. If you combine a weak approach to deliberate indifference with a broad definition of what counts as anti-Semitism or a broad definition of what counts as some other types of discrimination, then you end up, as Tyler said, with schools being incentivized to restrict speech, undermine academic freedom, and cause various problems. And it seems to me we can combat genuine discrimination, violence, and harassment without resorting to that. And if we do resort to that, we will cause, and already are to some extent causing, all sorts of very serious problems.
Okay.
Yeah, just
Sure.
so briefly to Tyler and Ilya. To Tyler, I apologize to my friends from the Biden administration. I'm not going to defend them against their accusations. It is possible to be simultaneously insufficiently strong in anti-Semitism, but also insufficiently protective of the First Amendment. That can happen. So to Ilya, yes, you've demonstrated that on IRA, not everyone agrees that you could disagree with it. The one thing I'm going to say, because one could argue for hours on any part of the definition, besides that it's generally agreed upon, that as it exists within the Trump executive order and the guidance of the Education Department, as well as most of the states that have adopted it, the examples of anti-Semitism can include speech, because speech can be anti-Semitic, just as speech can be racist, speech can be sexist, so on and so forth. That doesn't mean it can be prohibited. So there are lots of things that can be anti-Semitic within the definition that's now used by the federal government and many of the states, which nevertheless can be protected, should be protected, perhaps must be protected.
So I guess, though, if you put yourself in the position, though, of a general counsel of a university, how comfortable, how safe or how clear would you consider the lines, though, as far as speech of their students, you know, that's heard by other students, you know, in terms of, and then the universities, you know, has to show that they're not being deliberately indifferent. I mean, how much confidence would you feel advising your client university as far as what kinds of quote unquote, you know, what sorts of speech they have to respond to?
In civil rights in general, there are often going to be gray areas. This is not an anti-Semitism issue. It's certainly an anti-discrimination law issue. And the advice might be different if you're a public institution versus you're a private institution, and also your own rules as a private institution, and whether you're in the state of California or not. But generally speaking, I would say that if you are thinking of disciplining a student, that's going to, or a faculty member, that is going to bring up a very significant set of issues, certainly constitutional issues, but maybe other legal issues as well. If you're thinking about doing something different that doesn't trigger those sorts of rules, if you're thinking about what do we need to do to make everyone feel included, if you're thinking about doing something to make sure that you have protective services available, that is not going to create exposure.
Okay. All right, so let me ask, if we focus to the speech as it relates to the institutions themselves, for the panelists who are kind of more on the critical / skeptical side of what the administration is doing, do you accept, it seems like a lot of what's driving the administration's position, if you give them, look at it in the most charitable light, is that they don't really see this kind of sharp line between the sort of more egregious acts of anti-Semitism, a lot of which involve, conduct, and you don't even really need to get into free speech or whatever, but they don't think that you can separate those manifestations of anti-Semitism from the sort of intellectual monoculture among faculty, the sort of pervasive kind of, I guess, institutional, not so much maybe deliberate sort of overt discrimination against Jewish students, but basically the institution's responsibility for creating an intellectual environment where this type of thing is considered acceptable, and that in order to really kind of address the problem, you can't just focus on discrete incidents of discrimination. You have to try to use whatever federal authority you have to actually fundamentally change the culture of the institutions themselves. Do you agree that if you think that, that there is a big problem of anti-Semitism on campus, does the solution require changing the institutions in the way that the Trump administration seems to want to?
Do you want to go first, or shall I?
Oh, you shall.
Okay. Fools rush in where wise men fear to tread, as the saying goes. So I think it is not the job of the federal government in the United States to control intellectual environments.
Right, and that's completely a fair answer, and that's kind of step two. But I just want to, if you're the administration and you're trying to solve a problem, I just want to get a sense of whether the extent to which you agree that that's basically part of the problem that essentially if you don't do that, if you don't fix that, then you're just playing whack-a-mole with all these different incidents that may happen.
So if I were the administration and I was concerned about intellectual environments, I would first clean up my own house. For example, I would stop associating with people like Tucker Carlson and other known anti-Semites and Holocaust deniers. I would fire people they have hired in the Department of State and the Department of Defense who have an extensive history of anti-Semitism and so on. And only then would I consider myself worthy of concerning myself with intellectual environments at other institutions. But in general, yes, some higher education institutions have bad intellectual environments. The way that can be addressed in a free society is through competition and choice, not by the coercion of the federal government.
Okay, so we told you this would be a fun panel. Tyler.
Well, I think it's really hard for the institutions because the process itself was so messed up. We heard the justification that the government maintains broad contracting authority. I was wondering why the General Services Administration was included on early letters, along with Department of Education and Health and Human Services, to Columbia and to Harvard, because we discovered that they were using this theory called terminating contracts for the convenience of the government. That was the theory they were using. But when the government says, we're actually cutting it because you're violating Title VI, Title VI says you cannot remove funding unless these processes happen. And so when the government says, we are removing your money first, and now we're going to negotiate, the entire process is messed up. And when the institutions have billions of dollars withdrawn, and it says, now we'll negotiate, along with these demands that are just wholly unrelated to civil rights enforcement, I think.
Well, but that's the question.
Yeah.
I mean, that is their point, is that it's not unrelated because the civil rights violations are happening in part because of the intellectual environment that the universities themselves created.
The letter to Harvard said in all academic departments. What does the lack of intellectual diversity in the physics department have to do with campus anti-Semitism? I think I hear crickets. Nothing. And so, and if they actually showed their work, which they haven't been doing, they haven't been showing their work about why they think these things. They make these demands first, and
so do you think though?
Have post hoc rationalization later.
Do you not? So I understand what you're saying about the means, but do you not see a connection between sort of the kind of predominant intellectual climate on a lot of these elite campuses and the anti-Semitism that the administration is concerned about?
If there are particular individuals that are engaging in unlawful anti-Semitic harassment on campuses, universities can and should take action against those individuals. A dearth of particular ideas or an absence of ideas does not itself create an anti-Semitic environment.
Okay. Sarah, you seem to be the most pro and I don't want to put words in your mouth, but you seem sympathetic to the idea of the federal government using its authority maybe in other ways to try to promote intellectual diversity. And I guess I'm just curious how far would you be willing to, I guess how far do you think the Constitution allows that? Because if you look at both the demand letter to Harvard and the resolution agreements that have been, or the settlement agreements that have been entered into with the schools so far, there are things about reviewing some of these departments and requiring that there be intellectual diversity there. And I just kind of want the audience to kind of get a sense of how far you'd be willing to go on that front.
Well, I mean, not so far that I'm going to come across as, some kind of a crackpot arch conservative MAGA red hat wearer. But I will say the demand letter to Harvard, gave me apoplexy. It really did.
Can you just, for the benefit of, I'm assuming a lot of people haven't seen it, could you just kind of, what about it gave you apoplexy?
Yeah, among other things, there was a curricular audit that was required that made me very, very uncomfortable, and that would seem to fly directly in the face of academic freedom and the First Amendment. What I'd actually like to see, and I think this would be a better opportunity for reformation, and I'm surprised nobody at the Department of Justice has taken up some of the other avenues to address anti-Semitism on campus without without having to fall into the grooves singularly of Title VI and run sort of headlong into First Amendment jurisprudence analysis, right? Among those is the FACE Act, the Freedom of Access to Clinic Entrances Act. Now, that's going to sound like a strange adaptation for anti-Semitism law on college campuses because it was ultimately designed to prevent pro-life protesters outside abortion clinics and facilities, but what it also protects, upon heavy-duty laboring from the GOP on Capitol Hill, it includes protection of access to houses of worship. So where we see Jewish students, for example, being prevented from or being blocked access to Chabad houses or Hillel houses or synagogues on campus, that's an opportunity. We have seen the Biden administration throw pro-life grandmothers in jail for lesser FACE Act violation offenses. So I don't know why we're not seeing more investigation there, and perhaps it's just based on where we're actually seeing the encampments and the protests and where we're seeing a lot of the clashes with student police authority. I would also love to take a look at anti-masking laws and KKK Act, state anti-masking laws, because we know a lot of the people who perseverate in the sort of ideology of this being a genocide in Gaza and sort of advance pro-Palestinian interests, when they create these encampments, 9 times out of 10, their faces are covered. Where are we seeing prosecution under the KKK Act, or even, for that matter, state and local corollaries? Because many states have their own anti-masking laws as well. Love to be able to see that as an opportunity to eliminate and address anti-Semitism. So we've got other opportunities aside from Title VI. I would love some kind of preferential contracting. I mean, obviously within the bounds of what we see through the Department of Labor that doesn't violate federal civil rights law, make a competitive process for institutionalized grants that go specifically to organizations that have a commitment to intellectual diversity and to faculty diversity. There's nothing preventing the Department of Education or the Department of Labor from preferencing grants, from creating a competitive format where we're automatically seeing increased discussion on the fact that there is this sort of monoculture, right? There's intellectual homogeneity on campus, but this is going to be a problem generations in the unmaking, unfortunately, because it really is, at this point, baked into the entirety of higher education reform overall. But I'd love to be able to incentivize institutions to adopt intellectually diverse perspectives in hiring and in student admissions and with faculty and their institutional positions overall. I think value neutral perspectives on all of these educational propositions, specifically within higher education, coming in and saying we are an intellectually diverse institution, we do not take a position on A, B, and C, and then allowing for preferencing and competitive contract award on top of that, I think might do a bit of good.
Does the, is there a problem? So one of the things that I think Ken's comments pointed out is that there are things short of disciplining students that schools can do to, address the campus environment, but is there tension between that and the sort of institutional neutrality? I mean, do they, if the school says, hey, we're not going to discipline these students for X, Y, and Z speech, but just FYI, it's morally offensive and we wish they weren't doing it, or whatever it would, we still want X person to feel welcome here. Like, how is the school supposed to balance that?
I wish I had a very easy answer for you on that question. I love the idea of institutional neutrality and viewpoint neutrality. The problem is also that what we've seen is the cumulative effect of essentially decades of rampant anti-Semitism that is only now being addressed through civil rights enforcement, among other opportunities as well. But I think if we regulate time, place, and manner restrictions for speech, for example, whether it's your permission of encampments on college campuses or anti-Israeli or the Gaza war protests, and you get more stringent about exactly where these can transpire, how long they can transpire, and you put some boundaries on the actual application of student protests, which I think we would probably all agree are really the progenitors of a lot of the anti-Semitism that we see subsequently. And by the way, as sort of an ancillary note, there is a direct statistical analysis that shows a proportionate relationship between the activity of a Students for Justice in Palestine chapter on a college campus. This is the AMCHA initiative that's actually cataloging all of the incidents on college campuses, there is a distinct proportionate relationship between active SJP chapters and a rise in anti-Semitism on that college campus. So how we regulate our student groups, the student groups, if we're going to recognize them all, then we're going to make sure that they engage in conduct that is not violating criminal law or federal civil rights law or the like, so that every student on campus feels as though they have the exact same opportunity to receive an equal education.
All right, I'm sure, Tyler, I'm sure that makes you happy to hear that suggestion.
See, I did good, right?
I want to make sure we have at least 10 minutes left for questions, so let's just finish with a lightning round here. If you had one sentence of advice to give the administration on this issue, what would it be, starting with you, Ken?
Finish strong. You know, there's been a lot of early activity that's really good, and then a question of, are they just going to ask for a big check, a big fine, or are they going to insist on measures that will make a difference? They should insist on making a difference.
Okay. Professor?
Yeah. So I highly doubt the administration will listen to whatever I might have to say, so I'll just state a general principle I hope other people might accept, which is that it is legitimate for the government to punish violence and discriminatory action. It is not legitimate for the government, particularly the federal government, to interfere in speech, academic freedom, or general university governance.
Great. Sarah?
Wow, don't you have to limit it to one thing, because I actually have a couple of things.
One thing.
I would say ultimately get momentum toward amending Title VI to include religious protections. And then I'll just say also really quickly the Davis versus Monroe standard.
All right. Tyler?
My message is get it right the first time. The Trump administration has less than 3.5 years left, and if they're tied up in litigation for violating Title VI and its enforcement of Title VI and violating institutional autonomy and free speech rights, this litigation can take years and set back their enforcement to protect everybody on campus correspondingly. Get it right the first time.
Thank you. Okay, we have some time left for questions.
So my question maybe is a little tangential, but so when I was a young professor, I understood academic freedom to be, I'm a scientist, the permission to ask any question, to answer it with my research, and to honestly report on that answer. Over time, I've seen a conflation between academic freedom and free speech. And the problem is that faculty use their position of power increasingly to issue opinions outside of their area of academic expertise and then to claim protection under academic freedom. And it is true that they have free speech rights, but they also have an obligation to students. So my question is, at what point does free speech and academic freedom spill into educational malpractice? Meaning a faculty member with a position of power and authority, the limits of which are not always understood by students, making these proclamations. So that the answer to your question about the physics department, why is that a problem? Because the physics department no longer just opines on physics. Those people present themselves as experts on every topic under the sun, and their opinion takes on this power that goes beyond just protected free speech. So, you know, how do we rein this in? Or at what point in time do we make faculty responsible for committing educational malpractice when they opine on issues outside of their expertise, which is why this ideological monoculture has become a problem, because you have faculty opining on everything. So where is that line?
Professor, why don't you take that one?
So I guess I'm the only academic in the panel, obviously, therefore I have a certain self-interest, because obviously I'm not in physics, obviously, but in academia. What I would say is I would almost flip your question. I think universities have more of a legitimate role in regulating what we say in the classroom, where my job, for instance, is to teach constitutional law and property law. So if I spend my time opining on baseball, or for that matter on physics, they can legitimately say you're not doing what you've hired me to do, and what you've been hired to do, and therefore, you can be disciplined. Or alternatively, if my work on constitutional law or other things within my field is so bad that it doesn't meet disciplinary standards, they can restrict me for that. On the other hand, we should be wary of universities restricting what faculty say outside the classroom context or outside of disciplinary standards, precisely because we don't want to be in the position of somebody, even if they're a good physicist, but being punished for being too right-wing or too left-wing on non-physics issues and the like. So what I would say is that generally speaking, universities should have more authority over us when we're engaged in the educational function in the classroom, or when they're assessing whether our research meets disciplinary standards, than when they're assessing, whether we sign a statement about the war in Gaza or, express opinions on social media about various issues. Many of those opinions are stupid and ridiculous and may show that people who are experts in one field, do a bad job of opining in others. But if you try to crack down on that, then you will have more of a monoculture and more problems. And realistically, people who dissent from the dominant political views in academia, if you give universities authority over that, those people are more likely to be victimized than those people who are closer to the majority. And I would also not want the federal government, or state governments for that matter, to be able to try to compel obedience or to try to crack down on expression of stupid or even ridiculous or offensive views in that respect either.
So I think that was a great question from Undersecretary Jones. Two things. First, I think that even the American Association of University Professors has canonically acknowledged that extraneous speech is an exception to academic freedom, even in many classroom contexts. And that's even the AAOP, which we're now, I think, seeing increasingly as an extremist organization, which is less and less credible. The other thing is, I think it's wonderful that there is so much important, delicate attention to the free speech and academic freedom of predominantly extreme left-wing professors and student groups at a time when, do I have to say, that conservative and Zionist speech is extremely dangerous on college campuses right now. So if we want to be concerned about academic freedom, I mean, we're talking about the academic freedom of basically those academics who wouldn't have a conservative on their faculty in the first place. So they don't have academic freedom because they've not been hired. And for the students, the ones who have the least freedom are the ones who are simply terrified to speak in a way that is contrary to the predominant culture on campus. And that is a huge problem for free speech and academic freedom.
Okay, great.
Thanks.
Thank you.
Valerie Maloney, I worked at the Labor Department in the Trump 1 and a little bit in Trump 2, and so I was working on Title 7. In practical terms, you can't get the Office of Federal Contract Compliance is gone, so you can't do anything through them. The Education Department is similarly shuttered, so there's not much you can do there. So it's, in practical terms, you may want to look at the state laws. I know with the Federalist Society, but for all those rights are in state laws for nearly every state, and you don't have the same limitations. If you're going to the EOC, you need 15 people. Mm-hmm. So sometimes as little as one person can file in a state. And it's the same, they do dual filing, which means that states do all the actual work, and then it just slows it down to go through the EOC. So I think a lot of people might be well advised to file directly with the state. You can negotiate more quickly, you can settle the case more quickly with a lot less fireworks.
No, I think that's 100% right. In fact, on my list of sort of all of the things to do to address anti-Semitism were corollary state and local laws that we could enforce, whether it's in contracting, whether it's labor and employment, whether it's in criminal law, whether it's, simple trespass, vandalism, battery, assault, all of those kinds of things. We're not seeing enough activity, for my mind, from any of the states that too bear responsibility for a lot of what's happening.
File with them. They're a lot more, they move faster.
Yeah.
Thank you very much. Sir?
Hi. I wonder if you could address the kind of pervasive issue of, we have a very large federal government, it throws billions of dollars at higher ed, and higher ed happily takes the money and then says, then starts rattling off its rights, and you can't do this, and leave us alone. I mean, to me, this is a dynamic that is so pervasive, and it was really offensive to see all these college professors just not want to be held accountable. And when you invite and take billions of dollars in federal money, I was shocked actually how much federal money goes into higher ed. Not talking about Pell Grants to students, but to me it was sticker shock. I hadn't realized it was so enormous. And I wonder if you could address the fact that when people see misbehavior and riots and intimidation on campus, and billions of dollars are going to fund this industry. Oil companies raise 5 cents a gallon, and everybody wants to sick the government on the oil companies, but higher ed just leaves students threatened and property damaged and riots spilled out, and we're giving them billions of dollars. So I wonder if you could just address that kind of backdrop.
Sure. So I write in the area of spending powers, and if the argument is too much federal money is given to higher education, although it's against my interest to say this, I agree. If you just want to cut funding across the board for a lot of things, I think that's fine. My concern is simply that funding not be used as leverage to affect things like speech, academic freedom, the intellectual climate, and so forth, because that is dangerous a dangerous power for the federal government to have. And moreover, it's not a power that in most of these cases has been authorized by the branch of government, which is supposed to have the power of the purse, Congress. Instead, I would rather see a world where there's just somewhat less, maybe a lot less federal funding all around, and more of these kinds of issues of intellectual climate and the like, and ideological diversity are left to competition and choice rather than to federal coercion, because the more control one single center of power the federal government has over these things, the less diversity and choice we're likely to have rather than the more. And I think conservatives historically have recognized this in other contexts, but for the moment at least, they seem to be forgetting it or ignoring it, many of them in this context of higher education, also with respect to some other kinds of issues. So I think there is a difference between simply saying these institutions should have less federal money because it's not worth it or because it's being spent badly, versus we're going to use the federal money as a club or as an incentive to impose our own vision in a wide range of areas, I've noted before, go
But
far
you're inviting
beyond.
that. You're inviting that when you take their money.
Yeah, so
And when
no,
professors
because-
go off and free Palestine and they want to intimidate, well, isn't there some warrant for federal intervention to stop that?
So I don't want to repeat everything that I said before, which is that there is warrant to stop discrimination banned by federal law. There is not warrant to impose all sorts of other things that this administration is trying to impose. And there are some things where the appropriate remedy is, as we discussed a moment ago, through state and local law rather than through the federal government.
Okay, thank you. One more question.
So Tyson Langhofer with Alliance Defending Freedom. I litigate on public university campuses a lot, and one of the things that I see is that there's tons of policies on campus that actually prohibit all of this activity. Like all the activity at Columbia, they were violating all kinds of university policies and actual city laws, state laws, and so forth. And it seems to me that there is an equal protection claim in many times in these situations because universities fail to actually enforce the policies equally. This was exactly why the Equal Protection Clause was enacted, because the southern states weren't protecting, the black population. And so I had a question about, what do you think about why is the Equal Protection Clause not coming in? And two, would a robust use of that against universities showing that, hey, you are damaging this population and maybe, having some large, settlements and so forth, would that be a disincentive or an incentive for universities to do this? We've got multiple lawsuits pending, where it's shown that these universities are just failing to enforce their laws, across the board for various populations, even though they've got the ability to do so.
Ken?
I'd love to see some more, actually. I'd love to see Equal Protection Clause claims, and maybe there's a reticence after Students for Fair Admission, because I think, we've answered that question, and so we don't really have to get into the whole Equal Protection Clause analysis anymore. But I think it's a tremendous opportunity for real reform in public university spaces.
So I think the big picture point is that what we're talking about is double standards, and that is what we're seeing at all of these institutions. Some of the institutions are private institutions, though, right? So we don't really have the equal protection, but some of them are public, whereas a private institution, it might be something more like a Title VI or Title VII different treatment. Those aren't as easy as you might think, because there's always an argument from the defendant that, well, we treated A differently than B because the facts were different, and then you get bogged down in the factual disputes. So it's not as easy as you think, but it certainly should be one of the claims that's brought, because fundamentally, that is what we're talking about here, is universities failing to address the crisis of anti-Semitism, including some of these macro violations, in the same way that they treat even microaggressions when it comes to other groups.
Well, and I think that that's also one of the things that's, I think, going on with a lot of these debates, is that I think there's some folks who think that the answer to this is to include anti-Semitism the way these other things have been treated, which a lot of people have not liked what the government has done in that. And then I think there's maybe the more kind of fire approach that says, instead of just adding one more group to the list, why don't we, get back to or go to a more kind of, free speech, privileging kind of environment, and dismantle a lot of the apparatus that, now it maybe is being used for anti-Semitism and these other things, and maybe kind of get rid of it altogether and have, a different culture. So there's, I think, big differences in vision kind of at that level too.
Sure. I think my thought is, if we enforce the policies that are on the book, we can actually, don't have to address defining anti-Semitism, because we already have these neutral policies that are on the books, and then we can avoid some of those things, because I think, the actual, action we're trying to stop are the actual, conduct of running, Jewish students off campus, that kind of stuff, as opposed to defining, that more broadly. So,
Okay.
Thank you.
Thank you very much. Thank you again, DFI. Thank you for the panelists.
A big thank you on behalf of DFI and the Federalist Society to our final panel of the day, and to all our speakers who shared their expertise with us over the course of the conference. This closes out our formal program, but it opens the bar, so please join us in the lobby area for cocktails and conversation.